All right, guys, we're going to go ahead and get started, everyone. Hey, thank you, everyone, for coming tonight and braving the traffic. I do know the traffic was absolutely horrible, so thank you guys for coming tonight. You know, the reason we wanted to do the basics of estate planning, I'm not going to go into the depth that the attorney did a couple months ago. It's more of the things that Leanne and I and the team here have been experiencing on a personal level, just with friends, with clients, and friends of clients and relatives. So what we have noticed is, even though when you guys come in on an annual basis, we're talking about making sure things are titled properly, why it's important and everything else. So I want to go through just kind of the basics, the difference between a will and a trust, why we need to fund it, what that means, and kind of I'm going to share some things with you guys. We did get clearance from compliance. Typically, I'm not allowed to share any legal documents with you, even though everything is free on the internet, because if I share it, I'm dispensing legal advice, and I'm not an attorney. However, I have stayed multiple nights at a Holiday Inn Express. Okay? So let's talk about, so on your, this page right here. All right, so wills and trusts. We put this together because everyone needs to kind of get an idea of the difference between the two. So I'm going to explain it real quickly, the way that I understand it. And I know you guys have all heard this before, but it bears repeating. So a will is a letter to the judge that says, hey judge, if anything were to happen to me, everything goes to Leanne. If anything were to happen to Leanne, everything goes to me. It's called an I love you will. And then if anything happens to us, it goes to her kids, and this is how we want it. The judge says, I love it, that's great. Let's go ahead and put it in the dispatch, Instagram, Facebook, Twitter, or X, whatever it is, and every kind of social media. All right, does anybody know what that's called? Probate. Probate, that's probate, okay? The whole purpose of probate is to allow people to make claims against your estate. That's really what it is, all right? In the state of Ohio, you have what's called the 6-month rule. So if you file for a probate within 6 months, people can make claims against your estate. But if you wait 6 months and 1 day, they cannot, but you still go through probate, all right? However, anything that is titled properly, whether it's a POD, which is pay on death, okay, that's a benefit. Anything that has a beneficiary or beneficiary type statement is going to avoid probate. So POD, pay on death, that would be like your bank accounts. TOD, which is transfer on death, that's a hard asset like real estate, vehicles, okay, that's going to avoid probate. And then your beneficiary statements, whether it's life insurance, your 403B, 401K, 457, all right. And so you want to make sure that those are up to date. And we're going to touch on that, those types of retirement plans and why it's so important. Where a trust is a letter to a judge that says, hey judge, we don't need you. We got it all taken care of. And the judge says, well, what are you going to do? It doesn't matter. All right, you're not involved. And the judge is like, great. Okay. The reason that most trusts are not contested is the assets have already passed outside of the estate before most people realize it. And as a result, it's not contested and claims cannot be made. Okay? That's not a guarantee, but technically, right? And these are revocable trusts. So this is when everyone says, well, you know what? We've got to have a trust. You know, let's just have a trust. Not necessarily. Right, it's going to depend on your situation. You definitely want to get legal counsel, all right? But here's the problem with the trust. Even with the trust, we've seen this at least a half dozen times in the last 18 months, Leanne and I have. Friends and clients have spent thousands and thousands of dollars on a trust, and it was never funded. What funded means that the beneficiary statements are in the name of the trust. Okay, so that pay on death, transfer on death, the contingent beneficiary or primary beneficiary is in the name of the trust, so that all those assets avoid probate, all right, and go right into the name of the trust, and then it follows your wishes. Okay, that is the step that at least 70% of the people miss. They may get part of it, but not all of it. So what we have seen lately is bank accounts are being missed, 401ks are being missed, 403bs are being missed. Those are nonprofit, okay, retirement plans. Now when I say missed, so we manage 401ks for a lot of companies, and we tell every single participant every year, okay, update your beneficiary and print screen. Whether it's a 401k, 457, 403b, all right, if you don't have verification, even though that it's on there, because they'll update their systems and beneficiaries, they disappear. They're just gone. So if you don't have it,
who will update their systems?
Yeah.
the record keepers, those that manage the plans, so you have the record keeper, okay? And so if you don't have a record of who the beneficiary is, it's going to go through probate. So we got a call from a client. We've been managing their plan forever, and this, just the sweetest lady. Every time we met, have you updated your beneficiary statement? I'm going to do it. I'm like, you need to do it while we're here and print it off and put it in with your papers. I'm going to do it, I'm going to do it, I'm going to do it. For 11 years. She passed away a week and a half ago, and she never did it. So she has a son, she's survived by a son, and the son needs the money to help with the burial cost, along with taking care of her bills, making sure the mortgage on her house doesn't go into default and everything else. Here's the problem. It's got to go through probate. She's down in Hamilton County, all right? And the length process for probate down in Hamilton County right now is about 22 months, okay? Something that takes less than a minute, all right, it is so important, okay? So if you get nothing else out of tonight, it's the little things, it's the attention to detail that makes all the difference in the world, all right? So when we're talking about pay on death, transfer on death, all these things, you know, we're talking about these legal documents. So we've got examples here, and if anybody, now if you already have an estate plan, okay, this is why every time we talk, I'm like, hey, is your beneficiary statements up to date? You know, your bank accounts. This is why we ask nonstop, and I know everyone rolls their eyes at me. All right, he's asking again. Guys, it is so important, okay? The TOD, transfer on death. So we just, heartbreaking, just had a client pass away this morning at 3 a.m. from cancer. And by the grace of God, we were able to meet with them last week. Lane was able to see him actually put his mark, get some things notarized, and get everything TOD and POD on all the accounts. You know, and that's a big deal because she worked at the bank and the bank refused to do it.
Wow.
Because they could not witness him signing it.
No.
All right? So these little things, all right? The same thing with the safety deposit box. If you have a safety deposit box, all right, if you don't have a POD or TOD on that, all right, that's going to go through probate. Now, when you call up a bank, all you got to do is tell them, hey, I'm coming in, I want a POD statement ready, okay? I'm going to, if it's trust, I'm going to send over the funding letter, the instructions. This is what I want it to read. You've got to go in with your ID. You're going to sign it. They're going to medallion stamp it, which is the bank version of a notary. And you get a copy, they get a copy, you put it with your estate planning documents. Okay? So very, very important. So I have samples of a pay on death statement. You can't use it, but it's just a sample if you guys want to see it. We also have the same thing for real property. So there is a TOD, which is transfer on death. All right, this is accepted in the state of Ohio in every county, but it's county specific, so you actually have to fill it out with your property address and everything else. The cost typically when you do your trust, yes,
If you have a joint ownership with Sunseed, do you need to file?
it would be the second.
Okay.
So when both of you pass away, so that's a great question, Renee. So Renee asked, if you own a house joint, do you still need a TOD? And the answer is yes. So if it's joint, right, so Leanne and I, it's joint tenants with right of survivorship. So if anything were to happen to me, she gets it, okay? If anything were to happen to her, then it goes into the trust. So that's the TOD statement for the trust, all right? And then because it goes into the trust, it avoids probate, and the trustee is then able to go in and make those decisions based on our wishes.
And what are your thoughts if you haven't established
How
a
do you
state
think they
plan
come to the trust?
of reviewing that? How frequently would you do that with the person, the entity that established the estate plan?
You know, John, that's a great question. So there are law changes. Most people have estate plans. We just ran across one. I think the will is 41 years old. The kids have, their own kids, and one's expecting their own grandkids. Okay, it's a little outdated. So then you have situations where you could have gotten it done in 2019. All right. So why am I using 2019? Well, the Secure Act, all right, was enabled January 1st of 2020. So that changed how you leave things, qualified accounts, like your IRAs, 401ks, 457s, 403bs to your beneficiaries. They now have to take it out over 10 years instead of a lifetime, right? So if your trust is not updated, you typically, most attorneys, you take it back and say, hey, can you update this for the recent law change? It's a 50-50 rule. Half will not charge, half will charge you like 150 bucks. Because all they do is attach an amendment to your trust. Everyone signs it, you notarize it, and it's done. The problem is that when you have the next year, the Secure Act 1.5 update, and then most recently, the Secure Act 2.0, all right? But a lot of times, when they make those changes, they're broad enough so that it's really not going to affect the kids, or your beneficiaries to that degree, all right? So if the times that you want to make a change to your estate is if you have a life event, there's a passing, you get married, you have grandkids, and you're not allowing for those changes inside of your plan, or you don't know. And that's when you want to make sure that you have someone get in and review it. Does that kind of answer your question?
Yeah, makes sense.
Mm-hmm. The other thing that I have in here, powers of attorney. Okay, so the POAs, powers of attorney, are huge. There's two of them. One is a general power of attorney for finance, and one is the healthcare power of attorney, which includes in the state of Ohio a DNR, which is resuscitate, do not resuscitate, / living will. All right. So why do you want to actually have that filled out, especially on the healthcare side? Because you don't want to leave it up to your kids to make that decision on your behalf. Honestly, personally, I know I'm going to upset people, but if you do that, I think you're being very selfish. You need to take that out of your kids' hands. They've got enough to worry about. You guys need to make that decision, right? So they don't have to worry about it. And here's the other reason. We've seen it. Everyone thinks that families fight over money, and they do. All right, but the number one reason is healthcare before they pass. On power of attorney, this is just my recommendation, guys, just from my 30 years of doing this. You never have more than one person as your POA, okay? Because then again, you're putting, whoever that power of attorney is into a situation where I heard mom say this, no, I heard mom say this, well, she told me this and not to tell anyone, all right?
That happens.
It actually happened,
Yeah.
okay? All right, you just want one, all right? And as long as it's written down, it doesn't matter. Now, there's some other things that we've experienced here lately with powers of attorney, but that's probably for another class, another time. But make sure you get your powers of attorney. And look, anytime you come in, if you want it, now that we know that we're actually allowed to print these off, and we can send them to you. So there's going to be a sign-up sheet. If you guys want any of these docs, we'll email them to you, okay? You can fill them out, or you can bring them in and we'll notarize them. Or if you guys come in, we'll fill them out together and Leanne will notarize them, or Becky will, okay? Now, if you already have the estate plan, you already have it, so you're fine there. The one thing I didn't touch on is there are banks out there, we did not know this until recently, and then we found out that it's more common than you think. There are banks that hire companies that on a daily basis research death certificates, those who in obituaries, those that have passed away. And as soon as you pass away, they freeze all the accounts.
Oh,
What?
so they make money.
It's not that they make money, they're just protecting
everyone.
everything, right? So if it doesn't have a pay on death or transfer on death or some sort of beneficiary statement, including the safety deposit box, okay, it's gonna get wrapped up in probate. All right, so PNC is one, US Bank is the other, Huntington is the other, yes, thank you very much. Okay, couldn't think of who the other one was. So they actually hire companies to do that. So that's why this is important. The last thing I want to show you guys is the TOD for cars, transfer on death. Hey, Leanne, what is it, 25 bucks or is it free?
Yep, $15
$15
for the cars.
For the cars, okay.
25, actually the deed is 25, but
So-
15 for the cars.
So for cars, the way the rule is in Ohio is that if your vehicle is, all the vehicles total are under 75,000, they're not gonna go through probate. However, all right, if there's no TOD statement on it, you're still waiting 6 to 8 months to be able to title it in your name, which means you can't insure it. Okay? It is worth $15 in the hour and a half wait. Unless you go to, I think, Liam, there's a place in Powell and one in Delaware that it's just walk up, there's no one there, and it takes 5 minutes.
There's one right
One
on
in
Post
Powell.
Road, near Industrial Parkway. And
That's the best one to go to.
they,
Oh, is that the other
you're
one there?
You're in
There's
and
no
out of
doubt.
there in 5 minutes.
But that's
max.
only title changes. You
Title
cannot go
changes, yeah.
there for tags or anything else.
Right,
Yeah.
you can only go there. for
So,
taxation.
so if you guys, what's that?
Powell's closed.
Is it
No,
closed?
Yeah,
the
Papa's
one on
closed.
23 is the one that does
Well, the
titles.
one in
Yeah,
Powell.
but they didn't do titles.
Yeah, that was just
The
the
one on
driver's
23
license.
does titles.
So just if you guys want any of this stuff and you're not sure what you want or not, just go ahead and put your name on the list and we'll email all this stuff to you, all right? The TOD for real estate, we talked about this, you know, it's based on your county and it's 25 bucks
Now, if
to,
you do it through an attorney, it's $250, but again, they're the ones running it down there and doing it for you,
yeah,
so.
and I'm glad you brought that up. So, all right, I'm not throwing attorneys under the bus by any stretch, okay?
But I don't, that's not out of character, $250 is normal.
That's normal, but typically when you get a trust, they're gonna give you a letter, it's called, it's a funding instruction, okay? That this is how you want all your beneficiary statements, this is how you want it titled on your PODs, TODs, 401Ks, 403Bs, 457s, whatever they are. But they don't actually go and do it.
We do.
We won't do the house or the cars, but
No,
yeah,
yeah.
we'll do all the accounts for you, okay? But that's why when most people get their estate plans, they think, because they had the funding letter, that it's all been done. Right, so you just want to double check and make sure that your house, your cars, your bank accounts, everything is funded properly, so you don't have to worry about it, okay? So everybody gets this in your books. You know, the survivor's checklist, you know, we put this together 18 years ago. And we've updated it every now and then as some rules change. You know, things are so hard when you're experiencing a loss, whether it's direct, indirect, or whatever it is. And so what we realized is there's things that need to be done that day, within 30 days, within 60 days, etc. So we put together a checklist for you guys. So it's in your binders in the legacy section. But if you want it emailed, you know, I recommend, you know, if you guys want, we'll just send it to everybody. So that way, if you have anyone that's going through a situation, you can just email it to them, okay? It has our name on it. They don't have to contact us. That's not what it's for. It's really to, you know, so that everybody knows what to do next, all right? One of the other things that we have experienced since COVID, a lot of the way that a lot of these trusts are written, it goes from revocable to irrevocable. Does everybody kind of remember the difference between the two? Yeah, kind of. All right, I'll go through it real quick. So revocable means you still retain ownership. All right, I can revoke it from myself, I can revoke it from you, okay? So I still have care, custody, control over it. Irrevocable, okay, means that I no longer own it, I no longer have care, custody, and control. So from an asset protection and other things, right, it's safer. So the way a lot of the trusts are written right now is that it goes from revocable to irrevocable at time of death. And that's really what you want. Okay? Especially with the Secure Act 1.5 and 2.0. Now there's a couple things. You don't have to take notes on this, okay? We do this for you. When it goes from revocable to irrevocable, it becomes its own entity, kind of like a family LLC or a corporation. It gets its own tax ID. All right, so it has to file its own tax return and everything else. So we'll actually help with that. We'll get the tax ID number. We don't do the legal work, we do the basic stuff, okay? And then part of that is retitling, you know, all of those assets, all right, into the name of the irrevocable trust. Why am I even bringing this up? Because that's how it has to be done, all right? When you go from revocable to irrevocable, everything has to be retitled. And in order to preserve the trust, if you go to the law firm that did the original trust, they charge you, God bless you, they charge you an hourly fee plus a task fee. And if you have numerous accounts, you could, now, you paid whatever, $3,000, $5,000, $7,000, whatever it was for the trust, and you could get another $2,000 to $5,000 bill to flip everything over, okay? That's what we do here. There's no fee, there's no anything, okay? So we will help with that. Just kind of keep that in the back of your head. You know, don't ask me. That's for the smart people like Leanne and her team. I don't understand any of that side, all right? She does that stuff all the time. Becky and Olivia and Tammy, they're like, you know, the wonder kids, okay? But the reason I bring that up is if you know of someone who's kind of going through that, just talk to them and say, hey, make sure that they're not charging you a fee. Because the last thing you want to have happen with everything that's going on is 30 days after everything's resolved, you get a bill in the mail from your attorney for a couple $1,000s. All right. Okay, so again, this was just the absolute basics of estate planning, kind of like the do's and don'ts, and why it's important to title everything properly. So, questions?
So the revocable, do we have to do anything? Is it everything already in a revocable, or do we have to do something to initially have it irrevocable before, or revocable before?
No.
We don't-
That's a great question, Sue. Did you guys hear that? So she said, do we have to, if I'm saying this right, do we have to do anything to change it from revocable to irrevocable at the time of death? The answer is no. It automatically happens.
But are they already revocable then? All the accounts are revocable or what?
Yes,
So,
yeah, so
the
once.
way they are, the way they sit now, until we die, or
That's
until
right.
you change it, they are revocable.
Yes, and the reason that they're revocable is so that you can change from one account to the other. So you still have control over, that account. So
It's
as an
the
example,
terminology.
it is, and it's
just
confusing.
confusing.
So let's just say that, so we'll use Steve's example of Huntington, okay? So let's just say that your account is at Huntington, right? You're like, you know what, I wanna go to BMI, credit union. If it's irrevocable, you can't do it, because you don't control it. But if it's revocable, which is why you want it like the trust, then you can. Yes, ma'am?
So if you have a beneficiary listed, do you still have to have any TOD?
No,
Okay.
No.
What are the?
But the TODs are specific for cars
Yeah.
for what are termed hard
and checking
assets.
accounts.
So hard assets are sometimes safety deposit boxes, all right, real estate and vehicles.
So if your bank account has your beneficiary,
That would be a POD, pay on death.
okay.
Yep.
So one or the other, okay. If you have assets in another state, or a house in another state, attorney said that I could put it in my will/trust here, because this is where my residency is.
Yes,
Agree
but
with
you can
that?
still, want to file, make sure that it's funded. So that TOD statement that we're talking, transfer on death, whatever state that's in that county, you want to make sure that it's filed with the clerk of the courts in the records department, so that way, if anything were to happen, it funds. Because that state, in that county, it's a different probate jurisdiction, so even though you have a trust, they're not gonna know to bring it over here, and it's out of their jurisdiction. But if you have that TOD on there, it's gonna follow your wishes.
Okay.
On the car,
Mm-hmm.
TOD, 75,000, is that, I assume that's total?
Of all vehicles,
Okay, but that changes.
yes.
How do you keep up with that?
You just,
You
that's,
have to keep going
you
in.
just keep going, yep.
So you mean, what, all vehicles as in every one vehicle, or
Total.
all four vehicles?
Yeah, so if
All
you have
four vehicles,
4 or
less than
10 or
75.
whatever, it's a total of 75,000. But once you cross that threshold, then they're probatable.
And keep in mind, you cannot do a lot of this as far as like the loans upon your cars, those types of things. Those, doing transfer upon death, it's when you own it.
Yes, free and clear.
So,
Free and clear.
it's
You
not
can't do it with a
gonna-
lease car, you can't do it if you have a loan on it. However, with your real estate, even if you have a mortgage, you
You
can,
can, yes.
okay? Thanks for bringing that
I
up.
just.
No, that's, yep.
And it's the total value, not the net value after the mortgage is discounted.
That's the total value. So, and if it's on a house, or even commercial properties, right? But commercial properties, you're gonna typically in an LLC or, and so really then you're just gifting shares, right?
The only other thing I wanted to touch on, because it's been very, very evident in multiple cases, power of attorney only holds till death,
Yes.
and it's gone. So just so you understand, if you have a power of attorney for financial or for health care, the moment that you pass, it's over.
And then the trustee takes over, okay? So it's a living directive,
Wow.
all right? But at death, then if you have a trust, the trustee then dictates.
Is the trustee the same as the executor?
No.
No, executors for a will.
For will?
Yep.
Okay, so trustee is strictly with the trustee.
Yeah, so an executor would be the same thing, but it's gonna be a little bit tougher because now everything's gonna be probated and your level of authorization is gonna be a little bit different.
Are you designating who that trustee is?
Yes.
So you do that.
So that's gonna be, so like in your trust document here, you have who the
Yeah, I
trustee
was
is.
sitting there
So
going,
once you die, then everything reports to that person.
have a
Yes.
power executive.
And you don't want to completely remove the executor out of that puzzle, it's just what authority they have over the big picture. The executor still has authority, it's just not as much.
Yeah, and here's the other thing too, because we had a situation a couple months ago, actually right before Christmas, of one family, where kids from different sides and, you know, who's getting what, and it was really, it was making sure that everything went into the trust so that whoever the surviving spouse was taken care of, but the trust was irrevocable, okay? And the reason it was set up that way, I just want to bring this up, was because the husband and wife wanted to make sure that if either one got remarried, those assets were no
Go to the
longer a marital
children.
asset,
Okay.
and that they would be divided up between their kids, that, you know, their respective families.
Doesn't the law already do that?
That's
Anything-
with her sturbies, are you referring to her
No,
sturby?
no, so what happens is, if you have a house, I'll just use that because that's the best example. You have a house and it's joint tenants with right of survivorship, one spouse dies, the other spouse, whenever it is, gets remarried, and that surviving spouse passes away, but they retitled it joint tenants with right of survivorship with the new house. So the new spouse, who's not connected to any of the kids, now gets to keep that property. So what happens is, in that revocable trust, like we were just talking about with Sue, when it goes from revocable to irrevocable, okay, that's why you get a separate tax ID number. It belongs to the beneficiaries in that trust. And also, and here's the other thing too, you know, it's not even a marital asset. So it protects liens, judgments, creditors, divorce, right? And for some kids and parents, it protects the kids from themselves, right? So you can put in spendthrift clause, so you know, they can get money at, because you know, you never want to leave an 18-year-old, you know, $500,000, right? Can you imagine the car that they would buy?
Lamborghini?
Oh, I'm sorry, that I would buy, yeah. Right, so, I mean, you want to, so the trust is, you're really, sounds horrible, I mean, you're expressing your wishes, all right, from the grave. And that's really what it is, you know, so I want to say you're maintaining control, but to a level you are. And that trustee, right, is making sure that your wishes are maintained. Does that make sense? Yeah. Okay. Any other questions?
A lot.
Fire away, Dixie.
What?
Fire
Oh,
away.
no, it's too much. We'll cover it over time.
Okay.
Because, you know, we're considering an irrevocable, well, yeah.
For asset protection, what we're talking about, yes.
And,
Yep.
you know, I have a lot of in-depth questions about that, but, you know, for us, I think makes sense.
Yeah, and so, you know, not the purpose of today, but, you know, from asset protection, Medicaid, even while you're here, right? Using an irrevocable trust, when you hear of Medicaid planning and Medicaid trust and blah, blah, it's an irrevocable trust. It's just a fancy way of, right? And so protecting the assets to make sure that, you know, if something were to happen, you hear all these stories, Medicaid, where the family farm was lost.
Yeah.
Or, you know, whatever. You know, mom had all this, and after dad passed away, you know, the majority of the money was gone, and then the rest, you know, there was barely enough for mom, and, you know, so, well, like long-term care, when we talk about having a strategy, you know, we're talking about that, that's a big part of that. Same thing with life insurance. You know, these are all tools. Everyone in here, I say this all, everyone's math in here is different, which means your goals and dreams and wishes, you know, what you're trying to achieve. But the tools that you can use, right, they're there. You just got to make sure that you use them. And the simplest one, the cheapest, it's the pay on death, making sure that your accounts, your beneficiary statements, you know, all of these things are funded in, you know, how you want them in there to go where they're supposed to go. One last thing that made me think of this, as I was saying that, not just in the state of Ohio, but in every single state in the US, you cannot leave money to a minor. All right, if you leave money to a minor, you're leaving it to the state. All right, the state will appoint a guardian ad litem, right? And every expenditure will have to be reviewed by the probate courts. All right, so don't ever leave money to your grandkids unless it's in a trust. That's the only way that you want to do that, right? Because, look, we all know the government does a great job of managing their money.
And just clarify, trust is different than leaving it to.
Yeah, so leaving it to your grandkids or someone under the age of
Whatever,
18,
who's
that would be
7.
like on your
That's different.
beneficiary statement, you know? Yeah, I'm gonna leave it to, you know, Katie, Susie, and Billy Joe, Jim Bob.
That's
okay?
their social, when
And,
you do it that.
right, you can't do that, because then the state is going to manage it. However, if you say, I wanted to go to those 4 of my grandkids, but I'm gonna put it in the Ed and Leanne, you know,
Living trust.
family living trust, and it just goes right into it, and then that trust is going to dictate, all right, who's gonna get it, how they're gonna get it, you know, those kind of things.
So if several aunts are putting money into an account for a grandson who's underage, what do they do with that then?
Those are UGMA accounts or 529s, and that's completely different.
They're
I'm not
custodial.
sure they're 529s, though. It's just-
Are they UGMA or UTMA accounts, unified gift to minors or unified trust to minors?
Just going into a bank account, they're just sending money and it's going into an account, you know.
Is the accountant Disney?
Well, kids can't have accounts. They
So-
have to have their parents on there with them.
It's gonna be a custodial account, so
Yeah,
there's,
it's
yeah.
Yep.
Okay, so it's
Right.
going.
So the only time that it could be in their name, which is still a custodial account, would be an UGMA, Unified Gift to Minor account, or an UTMA, Unified Trust for Minor. And a 529, it's still your money, right? It's a gift that you can take back, so it doesn't technically belong to them.
Another thing that we've done that I think can make a huge difference for your beneficiaries is to pre-plan and prepay your funeral expenses.
Absolutely.
Yeah,
That's a
absolutely.
huge gift.
Yep. And if you do that, most funeral homes now, especially now since the Secure Act, when you prepay, it becomes irrevocable, right? And that's what you want, right? You want that term irrevocable when you prepay everything, all right? I'm getting way off topic, but for Medicaid planning, all right, you're allowed up to, they just changed the limits, but it used to be $15,000 for funeral expenses if it was irrevocable. Otherwise, it's $2,000. It's a big difference.
Yeah.
Okay? And here is, and it's not hard to get to 15,000, but you know, there's a lot of funeral homes out there right now where, you know, it's significantly less than that. And so, because it's irrevocable, then it's a gift back to the family, the balance, right? So that's, so that irrevocable thing, we'll bring that up again. Any other questions, guys? All right, I know this has been extremely uplifting for everybody. So I was told I wasn't allowed to talk about the market because everyone should be able to sleep tonight. No, I'm kidding. If you have any questions at all, you know, let me know, but guys, please sign up for stuff. And Tammy will make sure that Chris gets all the PDFs out to everybody, okay? Thank you, guys. Eat, drink, be merry. Thank you.